And where are we on this? There was the hot water, the mailbox key.
I fixed the hot water.
Pardon?
Hot water is fixed.
Okay.
No mailbox key though.
You still don't have a mailbox.
They haven't reached out to me as well. I reached out to them, got no response. So I paid the $1,028 again.
$1,028. Okay. You paid that directly to them.
I paid that on
to the landlord.
Yeah.
On the 24th. Is that correct? Okay. So what's our balance at this point?
$2,654.
$2,654. And then I have June clicking in tomorrow. So
I haven't said anything.
What's your monthly rent for?
$1,028.
That's right. That's how we set that number. Okay. Okay, so this will keep us at the 20. We came down, but when could the June rent be paid? Do you know?
I don't know. I've been paying them almost every week. I can't afford to keep paying $1,028 twice a month.
No, okay, I got you. But so tell me what you can do. Because here's what I'm going to do likely, because you got to get a mailbox key. I'm going to put it out to the 14th. Okay.
Okay.
So what I guess I really was asking, between now and the 14th, what can be paid? Let's do it that way.
I can pay $500.
500
until I get paid on the 7th.
So 500 on the 7th.
Mhm.
Okay. So I'll put 500 on the 7th. That'll work. I mean,
I could pay the whole thing, but I'm just refusing to at this point. They're not willing to reach out.
Why?
I'm
You know
just-
what? She could have just let it slide.
I know I can't.
And I would have just let it just go. Like, all she's got is
This is-
500. Well, no, I could pay the whole thing, but
But I'm not. But I've reached out to them several times about just, if you get the late fees off, I'd pay it in one
all right,
month.
listen, just
They
listen.
don't want
Oh,
to. Sorry.
no, I'm just gonna let you talk.
Thank you.
You ain't gonna let me.
Plus, I walked here.
You walked here?
I walked here. So,
Okay, so here's the deal.
okay.
Get the 500 in. Can you? Is 1,000. Let me ask you, can you do 528?
I can even go, yeah.
Okay. I want to keep the numbers where I can. Okay, so pay the 528. So it's I get your point. I mean, I make fun of it, but I get your point.
Yeah.
Okay. And so then I will adjourn this out to the 14th. Can we get our mailbox key?
Yes, Your Honor. Yes. And then Ms. Hobbs, you're contesting late fees or asking for a waiver of late fees. What amount of late fees? Like what amount?
They weren't, she just told me the late fees were out of the question to waive. So I haven't heard from her since then. So I'm just trying to figure out a fair amount where I can,
She said to you what?
that she wasn't waiving. They don't waive late fees, just go to court, is what she told me. And
So I have to.
absolutely, on the court.
So with that being said, what amount are you asking for? Do you have an amount that you're asking for?
Not really, because I just got the ledger. Like
You
yesterday.
just, correct me if I'm wrong.
Okay,
She is looking, really what she's saying, at least what I'm understanding is, I ask you to do certain things. You guys really aren't doing it. You're not paying attention to me. The only way I can get your attention is not paying. And so then when I finally get your attention, you want me to do that plus the late fees. So whatever late fees accumulated during that period, I'm trying to get your attention. I don't think I should pay, because all I'm really trying to do is get your attention. Is that just another way of saying it?
oh, great.
Yeah.
You go viral for this moment too. Perfect moment. Perfect.
Yeah, I'm just gonna be known as like the Ebony House Whisperer.
I swear.
All right. So that, and thank you for saying that, I guess, ma'am. All right. So with that in mind, I think council can look at it, maybe talk to Ms. Hobbs at some point in between and see if some resolution regarding that can come up. And then maybe we can just get this resolved so that
That's
Ms.
And
Hobbs,
that's really, you know,
That's all I
Ms.
wanted.
Hobbs doesn't have to walk up here and
I do.
let me know that she walked uphill both ways.
I did.
All right.
Our phone number, our office phone number is on paperwork that you received under James Fink.
Okay.
If you want to call that, once you look at the ledger, if you want to call that, make any sort of offer, then I can present it to my client and I'll communicate with them about the mailbox issue.
That's fine.
Thank you.
Okay. June 14th, 2024 at
3 p.m.
3 p.m. Okay.
Awesome. Thank you.
All right. Have a nice walk back.
I should.
I got, and I got to say, you're better than me because I would have stopped halfway and just said, I ain't. Not realizing that if I walked halfway back, I would have been here. But anyway.
My job is like less than 5 miles away, so not bad.
5 miles?
I'm right off highway, so it's not that far.
5 miles.
Yeah. This is nothing.
5 miles. Walking 5 miles.
It's nothing.
Okay.
Have a good one.
You know what?
Gotta drop up.
If I had a job 5 miles away that I had to walk to, you know what they'd call me? Unemployed. Z.
In this court hearing, the matter concerns an ongoing landlord-tenant dispute focused on unpaid rent, outstanding balances, and unresolved maintenance issues, with the court carefully reviewing the status of payments and compliance from both sides. The tenant explains that the hot water issue has been fixed, but the mailbox key has still not been provided despite repeated attempts to contact the landlord, prompting continued frustration. The tenant confirms having made recent payments directly to the landlord, including a payment of $528, and the court establishes that the remaining balance currently stands at $2,654, with June rent about to become due. The judge acknowledges that the tenant has been making frequent partial payments but expresses concern that paying rent in fragments is financially unsustainable, emphasizing the need for a structured and realistic payment plan. When asked what she can reasonably pay before the next hearing, the tenant states she can pay $500 immediately and more once she receives her paycheck on the 7th, explaining that she is withholding full payment due to the landlord's lack of responsiveness regarding the mailbox key and other concerns. The court recognizes this position but reiterates that rent obligations still exist, regardless of disputes, while also acknowledging that tenants sometimes withhold payment as leverage to gain attention when landlords fail to respond. Discussion then shifts to late fees, with the tenant explaining she is contesting them, arguing they accumulated during a period when she was attempting to resolve unresolved issues and communicate with the landlord. The judge carefully reframes her argument, summarizing that she believes late fees should be waived because they resulted from the landlord's inaction rather than her refusal to pay, and the tenant agrees with that characterization. The court does not rule on the late fees at this stage, but encouraged counsel to speak with the landlord to explore a reasonable resolution, including possible waiver or reduction. To allow time for these discussions and ensure progress, the judge orders an adjournment until June 14, 2024, at 3 p.m., with the expectation that the tenant will make a $528 payment immediately and continue paying toward the balance once she is paid. The court also emphasizes the importance of resolving the mailbox key issue before the next hearing, noting that this basic service should not remain unresolved. The judge acknowledges the tenant's effort, including her walking several miles, to attend court and closes the hearing with a reminder that consistent communication, partial compliance, and good faith efforts from both sides are essential to resolving the matter without escalation or eviction. For more information, like and subscribe my channel.
Judge says time day for sentencing in this matter. Let's see, I met with Zach a couple days ago. We went over the pre-sentence report. There, as far as I know, no additions or corrections to be made. I would just ask that the court have some considerations as the fines and costs, because my client is indigent.
Are these the only things he's locked up on, or?
I have circuit court to deal with, but they're giving me a year with 8 months credit, I believe, if I'm correct, with Judge Patrick Collins Jr. And I just have
He's got to also
A
complete the
ticket.
Dawn Farm program,
yes, that's perfect.
which he hasn't started yet, so it's going to be a little bit.
And Teresa Blair on behalf of probation, Your Honor, it's my understanding from the circuit court appeal that is correct, that they are recommending, he has a violation of probation hearing, I believe that's on June 12th, that they are recommending the year. However, he does have a large credit. Mr. Burlett did ask in this case, I mean, this is a year-long case, he wouldn't have that much time. He is asking for probation and to do treatment, that therefore the recommendation is provided from probation as such.
All right.
I also have a ticket to deal with on the 5th, I believe, as well, but that
On Wednesday, before me.
I think so. On June 5th, I think it is.
What's the ticket for?
Giving false information to a police officer.
I don't think our PD represents you on that.
And that is correct, Your Honor.
Yeah.
Okay.
Because, okay, who represents you on your circuit court matters?
Judge Feaster.
Tercio Feaster.
He's in good hands. He's in good hands. Wait, don't lie. You're in good hands with Torchio.
Yeah, no, you are.
The judge will attest to that.
We've just been seeing you all over the news lately, so it's an honor to be here today.
Judge, I got that video's gone viral. I mean,
And
it's just,
CMC as well last night. Oh boy. I promise not to take your signature to eBay.
That's the first time I heard. Yeah, I haven't heard that one before, but okay. Mental note, don't sign anything. All right. Okay, sir.
Sorry.
No, you're good. Anything you want to tell the court before I oppose that?
Yes. I mean, due to consideration, I pled no contest. I just truly believe that, when I was with home and new vision, I made quite a bit of progress in my recovery for the first time ever. And I see where I made my mistakes, my recovery, what I shouldn't have done. And my sponsor, he wanted me to come down to Tennessee and be with him, but due to the consideration that I really believe I needed to continue the structure, eyes on me that, it'd be healthy for me to stay here. I do have a decent relationship in the recovery community here. And again, I did make progress, but I see where I made my mistakes at. It's no one's fault. I put myself in danger in my recovery. You get what I'm saying? So with that, I'm thankful that my agent, she recognized, she listened to what I had to say.
Miss Valera?
And instead of
She listened to you?
Yeah.
I'm shocked. Go ahead.
Instead of just taking the easy way out, of doing the time, I felt that it was necessary to keep the structure. Bless you.
Wow. I mean, God bless you.
I felt the need that, keeping that structure did helped a lot. And I was hoping that you take into consideration that I would do the Dawn Farms program in jail and be released to a treatment, again, to home and new vision. They provided everything I need.
I think he believes that if he gets sentenced today to that, he will move up on the list and he'll get into Dawn Farms a lot quicker.
And I would, as well as hoping you could put me on the list for Dawn Farms.
So you can get, okay. All right. And, okay. And I get it, Mr. Burlett, because what you did is, I guess with everything else pending, knowing what your sentence is in circuit, that you probably could have just said, just sentence me to time and then I'll just be done. And the very fact that you wanted probation says something about you and where you want to go. So let's see if we can try to get you there. Okay. On the DB second charge, place you on probation for a period of 24 months. You are to pay $655 fines and court costs, $720 probation oversight fees. I'm going to indicate as arranged by probation. I understand the request that you made, Mr. Kellewald. But I'm just going to indicate that's to be arranged by probation. Ms. Polera, I don't have any issue with coming to the court And once he's out, as he maintains his sobriety, lessening it over time. So you can earn your way out of those monies. How about that?
Yes, sir.
All
And
right.
also with Home Vision, when they provide the counseling stuff, they also provide drug testing. I already told her I will sign everything off so that way she will get information with no problems.
I have no problem. I have no doubt that you're going to cooperate with us. Because you know what happens if you don't cooperate with me, right?
See you back and hopefully not on Fox News with you.
Man. No, it's okay. No, I deserved that. I did. I deserved it.
Anyways.
There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete a domestic violence program as directed by probation. Complete residential substance abuse treatment, including all aftercare recommendations with status reports to probation. You're to complete a mental health assessment, follow all treatment recommendations, including medication protocol. There's to be no contact with Jessica Rohan or Jennifer Johnson directly or indirectly. No going to the residence or employment of those individuals. You are not to assault, terrorize, frighten, intimidate, threaten, harass, molest, or stalk anyone. You are not to possess any weapons, firearms, ammunition, or anything fashioned to be a weapon. You are to report to probation as requested by probation, including any home visits. You're to comply with all circuit court orders. So the review hearing, that's to be held September 9th, 2024 at 1 p.m. I'll order 365 days in jail, credit 49 served. You remain in custody until direct release to residential treatment, and then the balance is suspended. I'll do it on the other two then, I think. So that's on that kind. On count two, $50 statutory fees, 93 days in jail, credit 49 days served, defendant to serve the balance, defendant as part of that sentence to defendant to complete in jail Dawn Farm program. On count three, the malicious destruction of a building less than $250 statutory fee, 93 days in jail, credit 49, defendant to serve the balance, and also on that count, defendant to serve the in jail or to complete the in jail Dawn Farm program.
Judge, just a couple points of clarification. It sounds to me on count 1, on 2, and 3 that if he completes probation or is doing well, the probation department has discretion for fines and costs.
What I'm indicating is that, and how I've done it sometimes with certain people, and this seems like a good candidate, that as he continues his sobriety, we will be looking at waiving some of those fines and court costs so that that doesn't become clearly an impediment for him.
Okay, and the last question is on number 15. Okay, he's got to serve 49 days, credit 49 days. It says to be released to treatment, but on counts 2 and 3, you want him to complete I assume that's correct, the jail sentence, so he can do the in-dawn jail program.
I want him to do the in jail Dawn Farm program.
The class.
Prior to the
Right,
release.
and then he
After,
can still be released. We can work all of that out, but he wanted to get up on the list to be able to do that.
do
Right.
the class, and then once the class is complete, then
There's
afterwards I would be released.
correct.
Okay, tell me that later, then I'll write it down. Thanks, Judge. I appreciate it.
No, he
No.
understood what we were
So
doing.
I understood.
It's okay, Mr. Kellogg. That's what happens when you show up late.
Okay.
It's hard.
You have a nice day.
Thank you. 14A stands in recess.
In the sentencing hearing, the court addresses the case after reviewing the presentence investigation report, confirming that there are no objections or corrections to the report, and acknowledging defense counsel's request that the court consider the defendant's indigent status when imposing fines and costs. The court discusses the defendant's broader legal situation, including pending circuit court matters where a 1-year sentence with substantial jail credit is anticipated, as well as the requirement that the defendant complete the Dawn Farm substance abuse treatment program, which has not yet begun and may affect timing. Probation advises the court that a probation violation is pending in circuit court. With a recommendation for a 1-year sentence, though the defendant has significant jail credit, and notes that in the present case probation supports a sentence focused on treatment and supervision rather than extended incarceration. The defendant personally addresses the court, explaining that he entered a no-contest plea, has made meaningful progress during treatment at home of New Vision, and has begun to understand where he failed in his recovery. He acknowledges his mistakes, accepts responsibility, and explains that although he was encouraged to relocate to Tennessee by his sponsor, he believes remaining in the local recovery community with continued structure is essential for his sobriety. He requests consideration for participation in the Dawn Farm program while incarcerated, followed by release to residential treatment, explaining that structured treatment has helped him and that he wants to continue building on that progress, rather than simply serving time. The judge recognizes the defendant's honesty and notes that his request for probation, rather than a straight jail sentence, reflects a desire for long-term change, stating that it would have been easier for the defendant to accept jail time and move on, but that his request for supervision shows commitment to recovery. The court sentences the defendant on the primary charge to 24 months of probation, imposes fines and court costs totaling $655, probation oversight fees of $720, and orders that financial obligations be arranged through probation with the possibility of reduction over time as the defendant maintains sobriety. The judge imposes strict probation conditions, including no use of alcohol, recreational marijuana, or illegal substances, random drug testing, completion of domestic violence programming, residential substance abuse treatment with all aftercare requirements, a mental health assessment with compliance to treatment recommendations, and absolute no-contact orders with named individuals. The defendant is prohibited from possessing weapons and must fully comply with probation supervision, home visits, and any circuit court orders. A review hearing is scheduled for September 9, 2024. The court orders a 365-day jail sentence with 49 days credit served, with the defendant remaining in custody until direct release to residential treatment, after which the balance of the sentence is suspended. On additional counts, the court imposes statutory fees, jail sentences with credit for time served, and completion of the in-jail Dawn Farm program as a condition prior to release. The judge clarifies that successful compliance and continued sobriety may allow the court to waive or reduce financial penalties in the future, emphasizing that the sentence is structured to support rehabilitation rather than create financial barriers. The hearing concludes with the judge reminding the defendant that accountability and cooperation will determine future outcomes and that failure to comply would result in serious consequences, after which the court stands in recess. For more information, like and subscribe my channel.
I can't tell you the number of people who told me that one. Good morning, Your Honor. Daryl Barton appearing on behalf of the Lewises,
Right.
who are both present in the court today.
Yes. And Ms. Loudon is not present, and I'd informed, or sent a message down to the courtroom that I wouldn't call this until 10 o'clock, giving her time to get here. My staff did remind me that at the last hearing, I believe on May 28th, she's also not here, and we adjourned it because she said that she thought it was at 11 instead of 9. We adjourned it out so that everybody wasn't helped. There was a confirmation from her when we gave her the new time of the 9 o'clock. She confirmed that it was 9 o'clock and she is not here. The only thing I did not check, can we just run down to courtroom C and just make sure she's not here? I should have done that on my way out. I apologize.
That's all right. We'll wait.
Did Miss Barton say wait? In all the years, that's probably the first time ever.
What did
You're
you just say?
usually I said you'll wait. And I'm thinking that's got to be the first time ever that you have said that to me. It's like her case doesn't get called first. She's like all over me.
Last time you're going to check my ID too. At least you're not telling me I'm not who I am.
Yeah, that's true.
The removal has been received and should be.
I did see that. No, all right. Had my, so the record's clear. I had the bailiff, Mr. Allen, go check to make sure that she was not down in courtroom C. She has failed to appear. Would you like to take a default on this case?
Yes, Your Honor.
All right. Do you solemnly swear from testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Go ahead.
According to the information provided by my client, the amount outstanding that was originally asked for was $9,200 plus cost plus the statutory interest that has accrued since the original judgment.
All right. The 92 plus cost. The defendant the defendant having failed to appear, judgment will enter in the amount prayed for of $9,200 plus the cost, applicable cost and attorney fees and interest.
Did the case number change now that it's general civil, Your Honor?
I think the only thing that happens is a GC is added. Is that just a G?
Okay.
Okay, just a G will be added to that.
And we'll
So-
prepare a judgment for that amount
And I will
submit it.
sign it upon its presentation to the court.
Okay, I have another question, and that is, we also, come on. We'd also plan to submit a request in order to seize property with the judgment involved, if that, and ask that you sign it also when it's submitted.
I believe with the default, I have to wait the 21-day period.
That's right. So after the 21.
After the 21 days,
Days.
when that's submitted, then
I
yes.
don't want to have to come back. Your Honor.
Any post-judgment remedies you can submit, then the court will sign off and
Thank you. That's what and just to be clarified, they have a security deposit, which they've not touched through this whole thing. They want to be able to immediately use it.
let's do it this way. How much was the security?
It was $1,100.
1,100. Was any of the 9,200 rent or utilities?
Yes, 3,200 was the water bill.
Okay.
About $3,000 in rent.
Okay, then under the Security Deposit Act, they could use that
For
to cover
utilities.
for rent and utilities. So
Landlord
it's
tenant
not for damages. Just make sure that it's
Yeah. For utilities.
separated in that fashion. Yes,
I love it. Landlord Tenant Relationships Act.
yes. All right.
Thank you, Your Honor.
Thank you. Yes, ma'am.
We enjoyed seeing you on the national news.
Oh, I can't tell you the number of people who told me that one.
You and a lot of other people, and I guess I will thank you for that. All right.
In this civil proceeding, the court addresses the matter after confirming that both Lewis parties are present while the opposing party, Ms. Loden, has failed to appear despite proper notice and prior accommodations by the court. The judge notes, for the record, that this is the second failure to appear, recalling that at the previous hearing the matter had already been adjourned due to Ms. Loden's claimed confusion over the scheduled time, even though she later confirmed the correct 9 a.m. start time for this hearing. After verifying through court staff that Ms. Loden is not present anywhere in the courtroom, the court finds that she has failed to appear without justification and asks counsel whether a default judgment is requested. Upon confirmation, the court places counsel under oath and receives testimony establishing that the outstanding amount originally sought totals $9,200 plus statutory interest, costs, and applicable attorney fees accrued since the original judgment. Based on the defendant's failure to appear, the court enters a default judgment in favor of the plaintiffs for the full amount requested, specifically $9,200 plus all allowable costs, attorney fees, and interest. The court clarifies procedural details, noting that the case designation will now reflect a general civil matter, by adding the appropriate designation to the case number, and directs counsel to prepare the written judgment for signature upon submission. Counsel further inquires about post-judgment remedies, including a request to seize property pursuant to the judgment, and the court explains that such enforcement actions must wait until the expiration of the mandatory 21-day post-judgment period, after which all lawful post-judgment remedies may be submitted for court approval without the need for an additional hearing. The court also addresses the handling of the security deposit, confirming that it has remained untouched throughout the proceedings and clarifying that, under the applicable landlord, tenant, and security deposit statutes, the deposit may be applied toward unpaid rent and utility charges, provided that those amounts are properly itemized and separated in compliance with statutory requirements. The court instructs counsel to ensure that any application of the security deposit clearly distinguishes rent and utility obligations to avoid future disputes. With all matters resolved on the record, the court thanks counsel, confirms its willingness to sign all properly submitted post-judgment filings after statutory timelines are met, and concludes the hearing by formally entering judgment in favor of the plaintiffs. For more information, like and subscribe my channel.